we've had people expressing paranoia that they won't inform their family when they do a will, because that will incentivize them to do something to them.
Batho ba tlogelwa le bone those nephews ditlogolo tseo ba golela mo lapeng yana ka ba ka golela mo lapeng le bana ba rama ba golela mo lapeng ha mosadi mogolo a sena na tlhokagala bo maloma a bone le bo rakgadi a bone ba ba kuba.
I want to be cremated when I pass away, and then they find out after they bury me. Is it really possible to exhume, to dig me up? And has there ever been scenarios like that
no.
where they dug the person up and then they cremated?
Can you imagine if your surviving spouse is a litigious and determined person?
Have to get a court order.
They can arguably get a court order for your exhumation.
So even if it's not a bank, you're just an individual person who says you loaned that person, let's say 10,000 pula. If you can at least even show in a bank statement that, look, that 10,000 pula went to that person, then that is actually sufficient. Submit your claim, and assuredly the master will agree with that claim.
This is Mogobe Nuggets of Wisdom podcast. We enthuse, we energize, we inspire, and we empower intrapreneurs and entrepreneurs of all stripes in BW and beyond. Hello and welcome, dear viewer and listener, to another wonderful episode of Mogobe Nuggets of Wisdom podcast, the legal series. Our objective is to bring the law to you, and so that you are closer to the law in terms of awareness, in terms of cutting edge information. And we bring experts, people with the expertise to delve into these matters. And we have two such very talented lawyers. And as usual, I have Mr. Mabote, who gives the traditional and, if you like, the man in the street perspective on these things, so that we can understand them better. A little housekeeping before we start. We have a book, Momp Nuggets of Grit. If you're interested, please call us. It's available. It retails for $360. It's available here, second floor, Mogobe Plaza, or alternatively, if that is convenient for you, you can go to Exclusive Books at Airport Junction. Only $360, guys. Do support us and get the book. And of course, this whole program, this initiative of the legal series, is powered by Lerumo Mogobe Legal Practitioners, a law firm that's been in existence since 1991. I'm proud to be a part of that law firm since inception, and I'm delighted to also introduce to the studio. But before I do that, let me ask you to strike that subscribe button. It's very, very important for us to remain relevant. Press a like, press a subscribe button. We need it for our own survival, our own sustenance. Please do that. This is a continuation of a conversation we've been having, a discussion we had last time on succession and estates, issues of wills, codicils, succession. All those matters are of great importance, and we believe that they warrant another episode. And remember also to share your views and ask questions and write at the bottom, so that the next time we are back on, we're able to deal with some of those issues. And eventually we're going to find a way of making this entire show interactive, so that we can take your questions. But for now, the best is for you to just type in. Let me start on my immediate left. Can you kindly introduce yourself, remembering to share a little bit of your background as well?
All right. Thank you. Greetings, viewers. My name is Thokozile Nyerenda, and I'm the managing partner at Lerumo Mogobe Legal Practitioners. Yes, that's where I'm based. Thank you.
Okay.
Give you a Osenotse Mabote, head of marketing Mogobe Incorporated. Ketlabe ki bua mo boemong jwa setšhaba ke emetse maraheko gore rona re le batho ya ba leng gore ra ira molao re le ba dilo jang re botsa dipotso gong ono be half ka bara ka tsa tla go tla kono rotlhe ketlabe ke ire one tiro eo ke a leboga.
Yes, Phatsimo Letshwenyo. I am a partner at Kushata and Valamina Attorneys and a feminist. So I'm also an artist, and I'll just be putting in my insights as an attorney on the entire aspect of succession.
Okay. Thank you, everyone. I think it's fair to say our first episode on this subject was just generalities. We covered a lot of ground. Now we're going to get into the nitty-gritties and sort of break things down in granular detail and go into the heart of the matter. So the first question to get the ball rolling, I'll put it to Nyerenda right next to me. Can two people come together and make a will? Can a husband and a wife make a will together?
Thank you, Mr. Mogobe, for the question. A husband and wife, specifically married in community or property, they can make what it would be called a joint will together. And because at the end of the day, their estate is joint, therefore they can make a joint will.
And just two people get together and make a will, though that may not be related?
No.
Okay.
No, only in that scenario where there's a husband and wife married in community or property. But other than that, each person who is deposing to a will, or who's a testator in a will specifically, will be they'll be the testator. So it doesn't make sense having two people as testators. So each one of them would have to make their own individual wills, because each one of them will have their individual properties.
Okay.
Yes.
So even brother and sister or cousins, they can't do any of that?
No, they would each have to make an individual will.
Even if they own joint property?
Yes, even if they own joint property, because not all their properties will be joint, you see. So it will be complicated. It will be more complicated to say, we made a joint will for that property that we own jointly, but what about the property that the person owns individually?
Okay. Is that your understanding there, madam?
Yes, that is my understanding of joint wills, that it is properly reserved for partners married in community of property.
I'm trying to imagine a scenario where you are husband and wife, you are married out of community, but you have something akin to a universal partnership in terms of the way you handle your affairs. In other words, you are co-shareholders and you handle everything together. But is there an exception like that? Is there a situation where you can do a will together?
I think as was already mentioned, that becomes really tedious. It opens a floodgate of a very tedious affairs. So it was only proper for a couple that is known to have own jointly every property, every liability.
Okay.
Yes.
And how often should a will be updated to reflect current circumstances or conditions in terms of your property setup?
From my understanding, the rule of thumb is 3 to 5 years. Considering the change in the economy and the change in the global market and the likes of that, yes.
So you should be updating your will every 5 years?
It's the rule of thumb. It's not, you are not forced to do it, but it only makes sense that you would be able to do it, because it allows for you to include perhaps property that you have acquired in the long run and stuff like that. Yes.
Mr. Mabote, do you have any comment on the first two questions?
Kore ke utlwa ka ya o ile gore e iro after 5 years gongwe e iro ya ka ditlhopho ke sa itse gore a ha o sa dire jalo a go tla be gona le sengwe se leng gore gongwe molao ka nna wa itlhokomolosa yone kgang ya gore nyara kana gore a ro the first 5 years o ga wa ka wa update go mora gore re tsa ile nna and void ke potso gongwe ke ile ka kgela.
I'm not saying that you are obliged, but you are advised to take a look at your will. O lebeletse seemo, o lebeletse diphetogo mo lahatseng, o lebeletse le wena gore gongwe wa acquire tshimo go gongwe yaanong o batla go include mo willing. You know, it's those type of things. It just makes much more sense to go back to the will considering the change. But if there hasn't been that much of a change where you feel there's a need for you to amend the will then or review, then I feel like, yeah, proceed with your will.
Do you have any take on this one?
Not particularly. But just to say, you don't have to review, or let's say go back to your will after every few years, as what she stated. It's just up to you. But once you've made a will, it's just, and it is declared valid, then it remains enforceable at the time of your passing. So it's up to you really. If your estate has changed, let's say you've added properties, you have more children, anything that you do wish to change, you can change it.
And you automatically revoke the old one?
What happens is that when a will is drafted, there's a standard clause that should be in a will, and it states that all previous wills are revoked. So this clause, it covers whatever other wills that you have done, so that it ensures that there isn't two wills from one person. So definitely, as attorneys who draft wills, there always has to be that clause.
What do you do to ensure that the will remains legally enforceable after your demise? Are there any specific steps?
Okay, well, the law, there's the Wills Act, which does state what are the formalities of a valid will. So therefore, when you go to attorneys, what our job is to do is to ensure that when we are assisting in drafting the will, that we comply with what the formalities are for a will to be valid. So I'll go into those formalities. First and foremost, the will has to be written. It has to be signed. And the signature itself, mind you, it can be a mark, or actually you can have someone sign on your behalf. And then also, it has to have witnesses. Usually it's 2 witnesses who have to attest to the will that the will was drafted by the testator and it was signed by the testator. And if the will is more than 1 page, each page has to be signed by both the testator and the witnesses for it to be valid. And the process is that it is submitted at the master's office. So it would be only after submission, because it's not automatically valid, as much as even if the lawyers have complied with the formal requirements. But what has to be done is that it has to be submitted at the master's office, and the master will send a letter declaring that the will is valid. But this can go into another issue, and maybe it will be a question that comes in later on in the stage. But what can happen is that then the next question would be that what about if someone did do a will, but they haven't submitted it at the master's office? So, and let's say the will it meets the requirements of the law. So the question would be, is that will valid? So what happens is that in the Estates Act, Administration of Estates Act, it actually allows that even after a person passes away and there is anyone who actually has that person's will, they're actually supposed to still submit it at the master's office, and they will be the ones to declare whether it's valid or not. But you actually still can submit a will.
By submitting, you mean registration, or do the two go together?
It goes hand in hand. Yes, but I wouldn't say a will is actually registered. A will is submitted to the master's office, and then they declare it valid. You're not actually, it's not as if you're registering a trust. So when you submit a will, unlike a trust, when you submit a trust, you're given a registration number, what the number of what the trust, would be. But when you submit a will, that's it. They just stamp it that it's been received, and it will be the master who will declare it valid.
If it complies with the Wills Act?
Yes.
Okay, supposing you forgot to initial 1 page, or the witnesses forgot to initial 1 page, what are the legal consequences of that?
Well, as I said, that the process, it goes at the master's office. So that is the whole purpose of it being there. They will be the ones to review the will, and they would be the ones to write to the attorney saying that the will needs corrections. And then you resubmit it.
But obviously, if the person has passed away?
If the person has passed away, it still can be considered as a valid will. But remember, at the end of the day, it will still be up to the master. Because if challenges are raised, it will still be up to the master, who will declare that they're still considering that it's a valid will.
Okay.
Yes.
Phatsimo, in preparing a will, there's a person called an executor or an executrix. What kind of considerations should the testator take into account in choosing such a person? I suppose you could also help us by telling us what that person does exactly.
Yes, an executor is the person who is responsible for fulfilling the deceased wishes, particularly in the will. And I do not even want to lie. I'm not quite clearly familiar with the entire requirements, but I am aware that the person, the executor, should be the person who is of age. Yes, and that is
Maybe
my
that's
knowledge.
where you can jump in.
Yeah, that's where she can
Okay,
jump in.
what I, based on my experience, what I know that an executor is that there mustn't be a witness in the will, and there mustn't be a beneficiary of the will. Those are actually the two main requirements. And also, they have to be of age. So it can't be a minor
Yes.
who is an executor. So other than that,
Do you have to get that person to approve or to agree before you put them in your will?
No, you don't. What happens is that let's say you put someone. It's better. As an attorney, I would advise a client, make sure that you inform them so that in the future, when the will is being dealt with in the administration of a state process, because that's where it will actually be addressed after the person passes away and you are dealing with an estate issue. What would happen is that the executor will have an option to actually agree to being the executor or to actually reject it. And the master would just have to allow it. They do not force anyone to be an executor, even if they're the named executor on the will.
In other words, they can agree when you are around
Yes.
and refuse
And
when you are
change their
gone.
mind. Yes, they can.
In which case, what happens?
What happens is that because it will be administering someone's estate, well, someone else from the family would have to either be nominated or just, whether they're nominating themselves to say that, for instance, I want to be the executor for one of my parents' estate, for instance, or it can be in a family meeting where you are all agreeing that this uncle, for example, or let's say the husband or the father should be the executor. But you still have to tell the master that, and in most cases it will not be opposed by the master.
Yeah, and they do have considerable amount of power and authority, these executors. Can you help the viewer understand what those powers are?
Well, what an executor is supposed to do, at the core of this, what happens in an estate matter is that the master will be the one to authorize and manage, help the administration of the estate. So they are actually, I would say they are above the executor, because you can't just dispose of things anyhow. Everything you need to do, you actually need to get permission from the master, or you actually need to submit and report that this is what you have done. But when it comes to the practicality of it, what happens is that the executor is the one who's actually, after you pass away, the executor is the one who basically takes charge of the administering of the estate. So they're the ones who go report already to the master's office, and there's the process there, as I stated. But they're the ones who initiate that process. They're the ones who submit the death certificate, for instance. And then when it comes to after that, there are certain things that need to be submitted at the master's office, and they go by phases when you're dealing with administration of estate. So, for instance, you have to submit a report of the inventory. For example, that would be expected of the executor. And for example, depending,
Somebody might
yes.
ask, what is an inventory?
Inventory, okay, that is the property of the person. So basically,
The list of the property.
the list of the property, yes, the list of the property. So it's everything, whether talking about houses, companies, Even knowing that, okay, they had a bank account at the FNB, you just all put all that down. And some of the things that they'll be requested also to say if they know of any debts or of the deceased, or if the deceased is owing someone, so they're the ones who more or less the master will be looking at really to also provide information or to go find out more and report to the master, because obviously they won't know every single thing that has happened, but they'll be responsible to
in
go
submitting
find that
this
out.
inventory. Maybe you can tackle this one. Is the executor or the executrix expected to include the valuations or the value of the assets, or that is not necessary?
I do not think that's necessary. I think what is important is to gather information regarding what is included in the estate, what did the deceased person own, and the likes of that.
Mr. Mabote, do you want to comment so far on what you are hearing?
The executor o ne dithetsa tsotlhano ke potsa gore ga gona le dikoloto tse ya ka ntse a bua tse di tswang gore nyame go tsa ne di sa itswe di tla ditlhagwa dikolo tsa se se dirilweng se neelwa ene the master o tlhala gore o kolota sekoloto se se hetang gone go iragala eng gore
sekoloto se se hetang eng
ko ra ka ditlha gore go na dithoto a bo tlhala gore mme ano ntutse o na le tswane go na le ko kolotang teng madi a mantse go heta dithoto tsa gago gore go iragalang gone go.
You want to take that one?
Yes. So usually when a person passes away, the creditors are expected to make themselves known that this particular person owes me. And part of the reason why I believe that the inventory has to be taken is in order for a situation like that to be able to satisfy those debts.
Part of the inventory, Mr. Mabote, will indicate assets and liabilities.
Yes.
And the executor is intended to indicate what kind of liabilities exist. Obviously, if it turns out that some of these liabilities are secured, in other words, there are mortgage bonds, banks are involved, those get precedence because those are real rights, as it were. They get precedence over whatever assets that are there. So it means that those assets would have to be liquidated. It's a process. What I'm not clear on is whether the liquidation is done by the executor with the consent of the master, so that the secured creditor can be paid first. The debts are prioritized according to whether or not there is a bond registered, there's a mortgage bond or not.
How kolota batho mo ile gore ga se banka o kolota batho mo na le bospi jwa gore motho wa mo kolota go duela mang jaanong ha ile gore ampo go duela ke ra o sa nyala go se gore go tlhokala nna ke sa nyala yana mme ke kolota batho ba ntle go ngote motho wa go te nya bo ipola ile ka gore na tshaba dikoloto gore koloto tse di tsametse di sala di duela ke ma gore ne ke na le wile ke gore
You want to take that one, Nyerenda?
Okay. Excuse me. All right, but in general, I'll just generalize it. In the administration of a state process, there's the phase that is called the creditors and debtors meeting. So what happens is that where if a person has, if they're owing someone, right, and that person, you advertise in the newspaper, so you're just gonna have to be, alert when it comes to what is published in the newspaper. But basically, and especially if you know that the person has passed away, then you should know that will eventually come, since it's not customary law. But eventually that happens, and then it is for you to submit your claim to the estate at the master's office. So you do in the form of a letter, and you have to provide. It's better if you have evidence, because at the end of the day, it will have to be the master who approves, that says that okay, they're accepting your claim in the estate. So even if it's not a bank, you're just an individual person who says you loaned that person, let's say 10,000 pula. If you can at least even show in a bank statement that, look, that 10,000 pula went to that person, then that is actually sufficient. Submit your claim, and assuredly the master will agree with that claim. But it's a problem if you are just saying, no, it was a gentleman's agreement. You see now, it's your word against someone who is deceased. So in those type of scenarios, in my experience, if there is no proof of you showing something, even an acknowledgement of debt or something, if there's none of that and it's just your word, the chances are they will reject your claim. The master will reject
I'd like to
that
ask
claim.
the last question.
Yes.
How on if you have kids, ba le gore they are minors, ba banyenyane, mme o tlhokagala go nna le ntlo o nna le bone mo go yone. That house e gore ke mortgage. O bo sa o duele bo ipola go ngoronyana ke ipola yana gore bongwana ke ba sala le ntlo e bogolo ba sala ba nna le botshelo. Is it something why
so basically you're saying if you leave kids behind and the house had a mortgage, so the bank wants you to take it now
for the interest of the kids, something like that?
Oh, you know, the law is the law. If that bank was not actually, that house or the property was not actually owned by you, let's say you are the deceased, it was still owned by the bank. So the bank has a right, and as Mr. Mogobe was saying, has even a strong right, which is called a real right, over that property. So that is not a strong enough reason for them to not go for the property that is there.
What the banks do these days, and what is being encouraged these days, is to make sure that your property is also insured.
Yes.
In other words, in addition to it be mortgaged to the bank, there must be insurance which clears that upon your demise, which clears that entire debt. So it is a smart thing, and what if you're a viewer out there, you should make sure that even your mortgage property isn't covered by insurance, so that something remains for your estate in the event of your demise.
But I think that was a very interesting question. I actually thought it was going in the direction of maintenance of children upon a person passing away and leaving behind minor children. So now that he's brought that up, I'm quite interested, because it's something that I'm not privy on like what has been the position of scholars or lawyers in the legal field, rather, because I'm new here. In terms of a real right versus the best interests of the child, because I know that in a lot of cases that I've had to deal with so far, the best interests of the child are always considered to be paramount. So what has been the discussion around that?
No, I think that one you don't have to go very far. The fact that there's a mortgage bond means that you've signed away all other rights to say that this is a preferred creditor, and this person gets a priority over anything else. In fact, it is so broad. I think words like whatsoever are mentioned and used in those kind of bonds. So the effect of registration of a mortgage is that the bank takes priority. No matter what.
And also in the scenario when you're dealing with minors, when it comes to the best interest of the child, the court has to basically there has to be a guardian appointed, and they're the ones who assume that responsibility of the kids and their care, basically. So that's also like on another side. Is
there a difference in terms of the power of the executor in someone who's died intestate versus someone who died testate? And if so, what are the basic differences? How does the law view these people, those with wills and those without wills?
When someone passes away with a will, and that is testate, so basically in the will you state who the executor is. So it just simplifies the process. Now, if you die intestate, that is without a will, what will happen is you report the death to the master's office, and as stated, you start the whole administration of estate process. And then one of the first things that has to be done by the master is to appoint an executor. Now you see in those type of scenarios, and there's a lot of family disputes. So usually what would make it a possible scenario is that people could be each wanting to be executors. So it would have to be put your case before the master, and the master will have to make a decision who will be appointed as an executor.
And I have attended many of these meetings. They can be very, very emotionally taxing. They can be very, very painful, where if you died without a will, it's actually the noisiest person and the most assertive person in meetings, the most articulate, who may not necessarily have your best interests at heart. So the long and short of this message is that get your house in order and make sure that you don't leave it to that situation which I call the wild, wild west, so to speak. Yeah. Let's talk about the whole process of making a will. We've heard people expressing paranoia that they won't inform their family when they do a will because that will incentivize them to do something to them. And this is something we touched on in the previous episode. But I wonder whether you ladies especially are able to give your insights on that one.
And
Notify or not to notify your relatives when you do a will.
And it's dependent on you and the kind of people that.
No, I need your advice. Just.
Well, honestly, that is what I can say. That it really depends on you and the kind of people that surround you, whether you want to notify or notify them, because either way, it doesn't really invalidate the validity of the will.
So the paranoia is not justified.
That they would be, well, considering that there have been none that I know of in Botswana, but I know that there's a case of some lady in South Africa who was killing people for insurance, and those type of situations are the kind of situations that could leave people a little bit on the edge to say, but if I told Phatsimo that I'm leaving her all this property, she might
So would you as a lawyer ordinarily encourage your client to notify their spouses and their children? Let me not single you out. What do you think, Mr. Mabote?
ga se go bo siameng nna ke dumele gore go siame gore o bolelle batho gore ke go tlogeletse sennanne ga ke a go tlogelela sennanne ke dumela gore go ka tloga ga ira gore batho ba ilane ga ngwe le bana mo lapeng ba kgona gore ba lwele dio tse o santse o tshela o di dirileng ke tsa gore se se botlhokwa ke go itse go ba bolelela gore go na le will e leng gore ke dirile gore mang o tsayeng kana mang ga tsayeng ke tsa gore ga go botlhokwa thata nna go ya ka nna ke bona go ntse gore ne ke letsa go botsa potso ya gore executor ha a tla go dumela gore a execute tsone dio tse tsone ko master sekolo a bolelwa se se boteng ga will kana o sign he go ke tse gore a ona le a komela wa bala gore o tlogeletse manyeng jang pele ga a sign kana o monela ya la go tsotsa ba sana itse gona le mo willing ya gago
o ra pele ga a simola tiro ya gago
ke ra a ke gona le
go mna le go mo appointa o tshela gona le gore a simolle tiro se tso tlhokagetse o ra le ngwena
a santse o tshela gore a santse o tshela gore a motho o mo tshepango a o tle go itse phiritsa gore o netse ngwana gago mamang go ngetse ka re khantela ba re ke se ka le ba gore ke a itse gore o timile se mamang ke ne ke sana wile o ke nna ke itseng ke a go mmolelela.
So I think what Mr. Mabote wants to know is whether it's a requirement to notify the executor well in advance what's inside the will, or to show him.
No. With a will, even to answer your first question, with a will, you don't have to notify anyone. Other than you can just inform the executor that, I want you to be an executor of my will. That's where it stops. They don't need to know the contents of the will. They don't need to sign anything in the will. Nothing. You and the attorney are the ones who know what was drafted, and you just put their name, and that's it. But this thing about telling people about the will, there's a lot of superstition about it. But sometimes it helps to maybe inform one impartial person. So if it's a husband and wife, you don't even have to tell your husband, or your wife, maybe you can tell a sister, so when the time comes, they
will immediately tell their sibling.
Well, who says they're beneficiaries? But really, I advise clients basically to do what they are comfortable with. But I would also say, really, especially when it comes to, maybe even if you tell someone that there's a will, make sure that no one sees the will. No one should know the contents of the will. That's the main thing.
Okay.
Okay, well, how do they treat an inquiry when you go to the master's office? Who's able to have access, who's not able to have access to the will?
When the will is submitted at the master's office, you can't just go there as like a family member wanting
I'm just
to.
curious how it works.
So-
If you want to go and have a look, or
There's no
or
access.
who is allowed access? Your lawyer or what? How does it go?
Only if it's you yourself. I guess for whatever reason, maybe you're saying that your attorneys have lost their will and you want a copy of your will. Then that is the only scenario. But other than that,
It's a very confidential instrument. Even the envelope, when the will is returned to the attorneys, is written confidential. So I think access is very limited.
But a lot of spouses will pressurize their spouses to tell them, claiming that it shows they are not loved. How do you handle that situation? Is there any advice as a seasoned attorney that you can give?
that's an in-house issue.
Yeah.
I really just have to put it like that. But at the end of the day, I believe in a relationship, it should also be out of trust. So if one doesn't want to specifically say that, they're concerned that maybe you haven't included them in the will, those are now core issues of the relationship. Should just be like, look, I have a will, and don't worry, I have I have the family's best interest, and keep it at that. If you have a very trusting, and then you tell your spouse, relationships are different. Yes.
Ke botsa gore ha lo nyalane
What's your take on this one?
nna
Mm-hmm.
nna ke tsa gore o ka se ko mmolelele ke tsa gore nna ke dumela gore o itidimalele nna ke tsa gore o itidimalele go batla go se ka bula Pandora's box ebile ne ke botsa gore ke followa gore ke botsa gore ha lo nyalane lo babedi yana go gore a mongwe le mongwe ya ka lo babedi lo ratana lo one o mo itirela wile o mo ka itirela wile ya go mo ba itirela wile ya go ka lo babedi and marriage, husband and wife.
Yeah, so it's one of the questions I was going to ask, but
Okay,
go ahead.
okay, all right.
What was the question again?
The question is like, if I'm married,
Can
my
write
spouse
do
can
separate wills.
do separate wills.
As in, can partners do separate wills when they're married? I think as already addressed earlier, if you're married in community of property, a joint will is a possibility. But if you are married out of community of property, it's actually much more advisable to just have separate wills, considering that you both have separate properties.
What is not advisable? Or how you are married in community of property? Can they do separate wills in community of property? Me and my wife. we
You
do
can.
separate wills.
Yes, you can.
Yes, you can.
Oh, okay.
But just keep in mind that when it comes to distribution and the law of married in community or property, the other spouse owns 50%.
Yeah.
So the way you decide of what happens to the property, you must have that in mind. That 50% is not mine.
Okay, no.
Okay. Can a person refuse to inherit in terms of a will? One of the beneficiaries, can they just say, no, I'm not interested?
Yes,
Yes,
they can.
they can.
And how do they go about it?
No, isn't it now when a will is being dealt with at the master's office and you're dealing with issues of inheritance there, then they will say you have an opportunity to speak and to state your side, whether you have any issues with inheriting or receiving that property.
So what happens to that property if you refuse to receive it? Let's say it's a house.
You see, now that's why a will should be carefully drafted. So such clauses that you should put, you should say that in event, because it's also the same scenario is if, let's say, you're bequeathing something to a child of yours, and by the time, and let's say they pass away. So now the question would be is what happens to that portion? So it's also kind of in the same scenario where you refuse, what happens to that portion? So you have to put it in the will that in event of such, that they're whether rejecting the property or they have passed on, then you can state that it will go to their children if they have any children. You can state whatever wishes you want, or it will go to the rest. Should go to your wife.
Someone used
or
the
your
word
sister.
residue in another episode. That you must. Someone used the expression that you need to cater for the residue of the estate, whatever remains. What happens to it? So in other words, the will has to be carefully drafted
Yes.
to take account of the residue of the estate that is
Yes.
not covered.
Yes.
Yeah. Is there a feminist perspective on this one?
On
On the issue of wills?
no, I mean, I feel like my perspective from like the feminist aspect comes in now when we're discussing extramarital children and them being entitled to inherit when we speak of interstate. But I believe we'll delve into that.
Well, Ike, since you've started, tell us your views.
Well, what I generally just have an...
What is the law saying and what is your view?
Yes. So basically, when it comes to intestate succession, extramarital children are not entitled to inherit from their fathers. And unless, of course, we consider whether the parent was a tribesman, and then we delve into tribal laws or customary laws rather, and determine whether those particular customs cater for the extramarital children and whether they can inherit. So that is my issue, that particular classification, to say that extramarital children and the legitimate children. That is the issue that I have with this particular law.
So does the question of whether or not a child is born in wedlock or out of wedlock have any role in the law as to the ability to inherit?
It does. Yes, it does. And that's what I'm saying, that it disinherits, the law disinherits children who are born out of wedlock.
Currently. Regardless of whether it's customary or civil, it's the same story.
No, it's not the same story. That is my point. That when it comes to customary law, then we have to determine whether that custom caters, it allows
so
for...
It's a very elaborate inquiry.
Yes, then it becomes a case-by-case basis in that instance. And then we have to consider case law like the Hopkins case to try and guide us as to how to...
What is the Hopkins case?
It's just a popular case.
Tell us about it. We don't know.
What have I signed myself up for? But the gist of it, or the ratio of the case, is basically to try and determine or to guide us as to how to dissolve the deceased person's estate upon their passing in intestacy.
South African case or Botswana case?
It's a Botswana case.
Oh, okay.
Yes.
What's the traditional view on all this?
ke sa gore ke ra bua ga khantele gore ka Setswana gone ngwana ile ngwana ga go hela ka Setswana a ke motho tse kontle a ke motsola kontle ke le motho a re ke re tsotse ngwana mo be ke ya go nyala ke mo tsotse ka hale kgang ke gore ba bone gore a me ngwana o kwa gago ha ba ra ngwana go le ba maloma go ba itse gore o tsotse ngwana go gara semamang ba itse gore o ke ngwana o ke o tla go a supala gore o teng ha o tlhokagala ngwana a mangwara ta garata ha o kgagong dithuto wa neelwa ka gore ke ngwana wa Mabote kgang yena
o neelwa ka ba bang
o neelwa la ka ba bang
ba lenyalo
ba neelwa la ka ba bang ba neelwa ba kgagangwa la ka ba bang ba kgagangwa sengwe le sengwe go la ka ba bang ba kgagangwa mme se ke tsenteng ke itse gore go tsa ba ka se ka sekiwa ka gore e ba ka tse ka gatela ta go ka se ka sekiwa gore ene mme o ka tswa contribute le ke go le kae mo diong tse ga rrago mme ga se gantsi ntse le gore motho a go nna ya lo tswa ya le gore ga ne le sepe ga tse go te ne le bontlhabong jwa botshelo jwa ga rrago itse go mo Setswaneng ba lebeletse gore mme no lo kana go tlhala gore ngwana ene ngwana a go nna yalo o gona gore ba nna yalo mme gore o tsana ko ntse ya bereka le rrago a dira le rrago a bereka le rrago ntse go itse go te ke ngwana o tswang kwa ntle mme a le active mo lwapeng ha go ntse yalo ba maloma go kana borrago mo ba ga ba bana le ka go lekana.
So Nyerenda, let's deal with the capacity to inherit from in wedlock and out of wedlock children. What's your view of it, and do you agree with the law?
Well, my understanding of the law is that whether you are a child born out of wedlock, if there's no will, as I said, the will you can choose whoever who you want to inherit your estate. But without a will, whether you're a child born out of wedlock, you can inherit the child's share, the portion. I believe that the law has changed, so that part was abolished. So right now, as long as you are a biological child or an adopted child, then you can inherit the child's share as an heir.
ke botsa gore yaanong ga e le gore o ngwana hela o leng gore gongwe wa go golela hela kgong ko kanye le gore ra go tswa o le ngwana o bo golela ko kanye ko ga mmago wa bo mmago maternal e le gore batsadi ga ba nya ga ba tsana ra go tswa ko shakao e kana ko go ngakala hela ko e gore a ro golela bonna monna motona o sa go panele ene sepe bo tla go to tlhokaetse a ka ra sna na tlhokalela bo tla o machana gore kana ke itse gore motho o ke rre gore a re ke le nna ke batla boso jwa. Is that possible?
With or without the will?
Without the will. Phatsimo.
I'm giving it to her.
As I said, what I just stated is, according to my knowledge, as long as whether you've had a relationship or not, you know what I mean? Like, there are many different scenarios. So you may not even have ever spoken to the father, for example, but you know that he's your father, and it's not disputed, as in they don't raise it now when they're doing the division that this is not a child, because then you're going to have to prove, that you are the child of so-and-so person. But basically, you have a right to your portion.
It means then if they refuse, or do you have the right to say, oh, let's do DNA,
Yes,
this is my father?
those are the things, yes, paternities.
If you're out of age, you're about 1920.
Yes, because isn't it's
Well,
going to
they'll
be
have
challenged.
to dig out the body to get the
Those
sample.
are the things. Hey, I'm not a specialist in
The
that
DNA
area.
sample.
Or DNA, I think sometimes you are more siblings.
I think they can use
Yeah, they
his
exist.
genes.
Okay, all right. Yeah, it's advanced. Yeah.
Exactly.
Yeah.
You
You don't have to
In
exhume the
what
body.
sense?
I do believe no, sometimes we find that they go there ba le family engwe ni wana le no le wa golele ka ngwana o le a be go tshola bana kwa na kwa mona o a tlhokagala wena ha o tla o rwa go ra gore nya motho kana menele re gwate sa le o kgaga le ngwana o go alekana nyana ke molelekile wa ntse kwa nteng o did that right ke ra gore thuto e re rutang ha Botswana ba tla kola peng ba itse gore nya ha le gore ke rra go le gore ke monna mongwe wa mohumiana o lebelle hela ya mele gore ha tlhokaetse o tla go tsa ditsa ga ga go no ka go ema ko pele. Right.
Yes, what you're saying is right, by the way, and I think something that that's also fascinating about that is that even in instances where your child is adopted by other people, if you pass away, your child will be entitled to your inheritance, can inherit from you.
Well, they were legally adopted.
They were legally adopted. The paperwork was proper. Everything is in order, and they're recognized as the legal child of those particular parents. They can still inherit your property.
It's all about bloodline. That one's angate. If your blood
If they're adopted, yes, they join the blood. Adoption has the effect of infusing the bloodline, so to speak.
Oh, okay.
But let me ask the next question of, can a person have more than one will?
No.
Why is that?
Because you're only supposed to have one will, and when you do that will, you should revoke all previous wills that have been done. So there shouldn't be a scenario where there are two existing wills by the same person.
And if it is found that there's two wills, more than one wills around, how do you decide which one is valid?
They'll probably look at the
Or
most
operational.
recent one.
Even if there's no revocation clause.
Yes, isn't it now? It'll be put before the master. They would have to decide.
I'm thinking of a wild scenario where the first will covers assets A, B, C, and then the second will covers assets X, Y, Z.
Okay, so you see, in that type of scenario, I would say that it depends on the circumstances of the case. So because the other property is not covered in that will, then both wills can be considered. But if the second will was now stating other things in terms of the initial
So
property.
then, in
that
other
was
words, it's
stated.
possible to have more than one will, ultimately.
I guess so. If you put it in that scenario, it's possible, but you're really supposed to, and it's more, I guess, on the attorney's side. They should really draft them carefully so that you don't end up into such scenarios.
So, and that's something that I've always wondered. So, in that instance, as per Mr. Mogobe's example, where that latest will covers a certain portion of the property. We don't consider it as the will, and that it's just the will with the residual property, as per our discussion earlier. As in, like, I guess there are instances where a will would not necessarily cover everything. There'll be a residue in terms of the property. So even in that particular scenario, wouldn't then it be the case that that will, that is the latest from the many wills that have been created, is just the will that specifically wanted to give away a certain property to that legatee or whomever, and it has a residue. It has residue in property.
I think what your question shows is that there may be permutations, but like we discussed in the previous episode, a good lawyer, if you choose to go to a good lawyer, he'll make sure that there's a revocation clause that says this is the last will and testament and codicil, and all the previous codicils and wills are revoked automatically. So it just goes to show you the importance of having a legal expert, because in the absence of someone with the expertise, there could be a quagmire, there could be that confusion, and then your fate is left to the hands of either the master or a judge at the High Court if there's a dispute.
About what I say.
Yeah.
How only we are will or ira kgotsa mo Lerumo Mogobe legal practitioners. Abo ira go bo hela le gore wa ba kolota o tsaba go duela di charges tsa bone tse dizo. Abo tintiwetsa wa go go mboki chilisa. Wa go ta o tsena go bota o ira will engwe ona di will di le pedi mme tsotlhe di diule ke di a gentse gore di ka hamalao. Go iragala eng gone ho? Ke ra o didimetse ke a ira ke le se ke a didimala ke bolele o ke le mo gore gore ke tsa go ira will ka go ena wa ira will gongwe ga ise go e file ga ise ise ko go pastor
Di file tsotlhe.
ya ke tso go sa ba sala ipipila isa ise ke re ke ra scenario ya gona ya gongwe in between ya la bo ka ira galwa ke se go sena na isa ile wela isa ise go ira galang di tla di le pedi mme di tswa go di ya rentse tse go di sia.
Well, there's no ways that they would be filed at the same time. So the one that is the most current one is most likely what would be
Considered
used
as
as the valid one.
All right.
Especially if they cover the same assets.
Yeah.
Okay.
Now, let me ask you about the issue of mortal remains. There are some people who want their remains cremated. There are some people who want their remains thrown in the sea and things like that. To what extent does the executor, the testator, have a leeway to decide what happens to their remains?
I think that will be within the confines of the law, in that whatever it is that you want to be done with your remains should be within the confines of the law. For example, you can't request that your family eat your remains or something like that. However, the testator has that will to determine in that will that I would like to be cremated upon my passing.
It has a right.
They have. Is it a right? I mean, it's a choice that they have to state what they want done with their remains, to the extent that they can even state where they want to be buried. If they so want to be just buried, they can state that I want to be buried in Pumulong and all of that.
And it's binding on the family members and on the executor, is it?
Is it binding?
Well, that one, you can put a clause in the will that says what happens with your mortal remains. And as what she said, as long as it's lawful, then there's nothing. It's proper. But in actual practice, look at this scenario, right? When someone passes away, usually you're burying them within a week. So by the time people know about your will, or let's say it's only at the master's office, for example, and maybe the attorney didn't even know you passed away, for example, the will, and actually an attorney is not even supposed to give you the will. You see, that's not how it works. So in actual practice, you already be buried by the time that clause is being read. So that's the main issue with it. It's not very practicable in real situations, because you're going to be buried already, and obviously in
but
that
you
type
can
of
direct that your remains be cremated or be burnt. For some religions, they burn their remains. So, in other words, that you can put. As to whether or not it will be enforced or applied,
yes,
it's a different
story. Yes.
So that's another thing that I've always wondered, actually, like that line of thinking and everything, the practicality of it. Like I've always just wondered, so in an instance where, for example, I want to be cremated when I pass away, and then they find out after they bury me, is it really possible to exhume, to dig me up? And has there ever been scenarios like that where they dug the person up and then they cremated?
Can you imagine if your surviving spouse is a litigious and determined person?
Have to get a court order.
They can arguably get a court order for your exhumation, and if it's not opposed, they might get it. Who knows? If it's not opposed,
take it to court.
How do you see all these matters, Mr. Mabote?
Ya go dingalo yana kana ka gore ka Setswana ha o nyetswe o hitlhela ko monna ga go a go nyetseng teng ke tla boela ka go ra gore o tswa khatleng wa go nna ko kanya o hitlhela gone ko mme go tle go nna nako engwe gore o tle go twe nna ha ke tlhokagala ha le gore ke mokalaka go te nyana ke batla gore ke go hitlwa go ngutla batho ba irile ba ipaditsa ko mo mabitleng malatsing motho ta ipasetsa go te bana ba ga semama re hitlhelwa ga a ba nyalwa ngwa ba kwala will ya gore ke batla go hitlwa next to my brother and my father. Go Setswaneng ga go tsana go Setswaneng gore go te maybe le kana mosadi o kwa rona re motsere wa lowa gone go gore ke itse gore will a etlabele ga a will gore teng ba e badile mola o tla bo ya ka ya go willing kana o ya go ngwaong gore ba ba ngwaong bane ba re do we take the direction of the will or the cultural nonsense in that case?
If they see the will on time, then you take what the will says.
Okay.
If somehow the will is read on time, but as I said, I doubt that would be able to occur.
Can a will be contested, and under what circumstances can it be contested?
Yes, a will can be contested, and well, basically we first have to look at whether the procedure as laid out has been followed. To say that certain things have not been followed and I'm contesting the validity of this will, to say that it's valid. Forgery is another reason to say that the signature or the markings or whatever that is on the alleged will is not that of the deceased person, or it was there out of the consent of the deceased person. So that is what I can share, but I'll also pass on to her to fill me in where I've left off.
Oh, you've covered it. I mean, there are different scenarios of when a will can be contested. For example, maybe you're saying that person was on their deathbed, on morphine, for example, and they were not thinking straight, and you got it's like they weren't in their right mind to do a will at that time. So that's just another scenario. So it can be, and most likely it'll have to be a court case now.
And what do you do as a testator now? I mean, whoever is watching us now, to guard against all this drama and to safeguard themselves?
Okay, my advice is go to a lawyer, and who has experience in drafting wills, and they'll ensure that they are able to draft a valid will for you, a will that will be declared valid, following the law. That's really the best advice.
Get a lawyer up.
You can't draft a will by yourself.
Yeah, that is true.
Go to a lawyer, and it is worth what you have to pay. It is worth it at the end of the day, because it's either that or you are going to let the law determine on how your estate will be divided.
As a general rule, in terms of your experience, do most Botswana die testate or intestate? And if it's intestate, what have you witnessed? What have you seen that you want to advise the viewer about or against?
Okay, what I've noticed especially of these last years. I don't know whether it's because of such issues as COVID, but there's actually been an increase in Botswana wanting wills drafted. So I would definitely say that the demand or the desire for people to have wills has grown, and I believe that that's a change from what it was in the past. And to give an example, and I will always advise anyone that that it's best that you have a will. It is worth it, because I'll give one scenario that I've seen in my experience. So there was no will. So the person died intestate. What happened was that this woman, she had a child, and she got married. She wasn't married before, and then she got married. So her husband was not the father of the child. That child was not a minor when she passed away, was an adult. But what happened was that when she got married in community of property. So now you see, at the end of the day, the child is the child that she left behind obviously had the assumption that my mother, I'm inheriting this property from my mother. I know he's going to maybe get some portion, but she believed that she was going to be the one to inherit the bigger portion. And now this issue was at the master, and already it was from the get-go. The master even had to explain and say that the way it works is that when there's no will, and that the person was married in community or property, it will now be also the law which determines on how the property will be divided. So what happens is that already in community or property, you have the husband automatically is entitled to 50% of that property, and it doesn't stop there. Now the other 50%, what happens is that the husband is entitled to a child's share. So basically, because she was the only child, that means that at the end of the day, she was only entitled to 25% of the property, and the husband was entitled to 75%. So you ask yourself, and it was even the master was like, this is why we also advise people to do wills, because you could obviously see that the intention
to absurd outcomes.
Yes, and mind you, that house was the mother's house. So the husband didn't even help build. It was already there when he came. But just because he was married in community or property,
There was no will.
and there was no will.
nna go nka tsena ka ya ntsa bua ka yone gore kana gore sekgwa se na le ha se siameng teng le gore a sa siama teng go ira o ile gone go siame go ntse go diriwe lo nkutleng ho mme mo Setswaneng ya ka ne re bua maloba ka marriage ha wa go nyala mosadi mo itlharana le bana o bo mo nyala wa le motho a re go ga ngwa ketse le gale ya ka Mr. mo go ne re bua maloba go ate a wa getse mmeo ngwana o mo itlhalang ga o ka ke wa ba nyala bo nna mo lapeng lo o tshwanetse gore wena a bo o tsa mosadi wa gago wa go maagela go sele o tlogela ngwana o le hale le lwapa lwa teng go le mo recording ko ga teng go khotleng gore lwapa lo le lwa bana ga se lwa gago jaanong gore a gore le a le gore o lo le community of property lo irile jalo ga go ta go se ke go go jampe go supile ha le gore lwapa lo lo tlogetse lwa go le mo ke tsa gore le ya go tsena ko pele go ka nna botoka go ntse yana
So you ka Setswaneng e botoka.
ka go tsane e botoka thata ka ba re lebetse ra ke lebetse tsa go ngwa ya go ke se gore wane ha o tlhala motho ga jwa ta tsa tsana mo lapelo motho wa mosadi a ikagetse lwapa la gago o le re o rwa monyala bo ta o nna le mo lapelo lo o batla go la bo bile o batla go moja boso go letlele tsontse ro mo tse o mo ntshe ho we go ira lwapa lo lo sele o swele bana ba ngo sele thuto tse le tsotle tsa bana bale bana ba lwapa lwa ntla wa go ga lwapa lwa go bobedi le mosadi o sele
I mean, I think I hear what you're saying, but in a way, I actually understand the position of the law to like a certain extent, because I think generally when this particular law came about, it was to say if you are married in community of property, that is the example I'm using, is to say this property belongs to the both of you. So it looks very strange when you think of it as, this one came in with this and this one came in with that. But at the end of the day, there was a union and that property belongs to the both of you, and you are entitled to half, whether you came in with a pot and the other person came in with a car. It's now your wife and yours is pot and car, and you're entitled to half of that property. And so it makes a lot of sense, but also it would, as she has already explained, it would be so much easier and it would make it less strange if there was a will to try and balance everything out, to say my share should go to my daughter as per that particular scenario. So I think I understand it, but also that's where the importance of a will comes in, to try and balance out these kind of situations.
Nyerenda, you're single and then you pass on. No children, no husband, no wife, no spouse. Who inherits if you died intestate?
Your parents and your siblings.
How does it work?
How does it work is that if both are there, let's say you also have parents and then you also have siblings, and mind you, it doesn't matter whether they're half siblings, as long as they're your siblings, then they each get equal portions.
Oh, is that reasonable? Is that fair?
That's why I have a will.
Yeah.
Hey.
So that's what the Administration of Estates Act says.
No, that's in the Succession Act. It specifically states that whether you are married in community property or out of community property, but you do not have children. So let's say even if you're married, what happens is that only in community property, what happens is that your spouse gets the 50% portion. You'd also think that the spouse will inherit everything, but that's not actually the case. The spouse will get the 50% portion of in community property, and that other 50% will be divided how I just stated.
No, but I'm saying you don't have any children, you don't have a spouse in the scenario I gave you.
Yes, so in that scenario, it will be equally divided, as I stated, between your parents and your siblings.
Regardless of the number thereof.
Yes, they will just each
In
get
other words,
equal
does
portions.
a parent rank the same level as your siblings?
That's what the law says.
There's no prioritization.
No, there actually isn't. Not in Botswana.
Okay. Isn't that a strong argument for getting married then?
How so? I'm
Yeah,
curious.
it's a strong evidence.
I'm so curious.
It's a strong argument to have a will.
It's a
To
strong
have a will.
argument, honestly.
To have a will. Now I'm saying
To get married, to make sure you have somebody who can inherit.
A larger portion?
If you're not married, then won't you be happy that it goes to your parents? But hey, some people don't get along with their family, so they may not actually want their family to inherit.
Which is where will would come in again, honestly.
Yeah, khata wa rena ke mo mathateng ka kono ka gore ha ke na wile maybe ha ke a nyala gore ke gore go kgaoga ngwala yana o itlhela ya gore go tswa yana ya ka in my case nna ke na le my nephews ba gore nna ke o ntlogetse le bone gore ke ba tlhokomele gore bana ba modimo ya gore ha ke na wile kana gore ha gore nka tlhokagala e tlo gore di tsa ka tsotlhe di ne le bon khonne ba le gore bone se bana le malapa ba bone sengwe sengwe go iteba ka bo gare ale ba le gore da my nephews,
parent and your siblings.
go tla tswa mo go tswa mo go bone gore a ba go ha ditlogolo tsaka.
Yes.
Nna mona go ya go pego kitso gore ha ke tlogela ke batla go nela ditlogolo tsa me gore a re mme ya go ntse tloga gore ha ke sa ire will gore ha ke tlogela go a go nela hela bonkgone ha ke re bonkgone se ka ba tsa sepe ke a ile gore se ka ba tsa sepe, but I'm saying gore go botlhokwa gore o nne le that will gore o tle go gone gore o laole gore mang o tsaye maga na ke ntse ke tsa gore ke tsa gore ha ke tlhokagala do tsa ka di go neelwa my mother ke ra nna ka kitswanyana menzi ke nana ya go mpego
But
to
in that,
serile.
I'm so sorry, I assume in a position where I'm assuming that's like your brother or your sister's
The late sister's children.
Yes. Wouldn't they not be entitled to that big sister's share? Like, isn't that the scenario? Like, I get it, you are not married, you don't have any kids. I'm asking you guys about the law here. In that instance where the big sister has passed away and they have left behind those children and he passed away, he doesn't have a will, and that his property has to be divided between the siblings, right? So wouldn't there be a certain share that was specifically meant for that sister who has passed away that now has to go down the line of inheritance for her? Would they not be entitled to it?
I believe so. Yeah.
They will be.
Hmm.
Okay, then my understanding is right.
I must caution that that's what common sense dictates. But if you don't have a will, there's no guarantee
that will happen.
That will happen. So that goes back to your initial argument. Like, get a will.
Correct.
Not only that, if one of the siblings is very argumentative and very, very assertive, they might be able to bulldoze their way into getting more than the other siblings.
Common sa gore batho ba tlogelwa le bone those nephews ditlogolo tseo ba golela mo lapeng yana ka ba ka golela mo lapeng le bana ba rama ba golela mo lapeng ha mosadi mogolo a sena na tlhokagala bo maroma a bone le bore kgadi a bone ba ba kuba
I've seen it.
ba ba
I've seen
kuba
it.
ba ra re nyago ha se ganyana ntse le gore ke bana ba gaisedi ba ba kuba gore mola o sireletsa go le kae bone bana ba wa ke ntse ba re lebeletse bo gore ka gore ba ho ka mmabo mme anong mona go ntsi ka ra ba lusa di case ba lelekiwa ya la ka kare ke di ntja kana ke a ke tsore mola one go wa re. What is the law saying about that?
About an instance where children are chased out of
The household.
the deceased person's household,
Yeah.
who had been their caretaker.
Yeah.
I mean,
They're old, not
It
minors.
happens a
oh,
lot.
they are not minors.
They're not minors. They are there
Oh.
because the mother was the sibling. I get.
No, I've seen it. Now I've seen specific cases. Actually, a case has come to us in the Kotla where the young man was taken as a child and taken care of by an older lady. And then when they reach a certain age, the older lady passes away long after they reached maturity, after the age of 21. And then, of course, this one who's now the child, the direct child of the older lady, would then just kick them out. And it's very, very difficult when they're in possession of an asset such as a house, while the law is taking its course to find a way of giving them any rights. Because remember, they are not the bloodline.
Yeah.
And remember, they've also attained majority. They have over. So it's difficult to argue under either the Children's Act or to make an argument under any other basis. So they end up losing.
Even the nephews will lose in this case.
Yes. When they reach a certain age. I suppose at a lower age you can go to the High Court and argue as the upper guardian of all children that the court should do something. But beyond a certain age,
Adults.
So in this
On
case,
their
what
own.
the best thing to do for me, so my mother to do is to make sure that she writes a will so that those
Yes.
those kids are protected.
Yes.
All right.
That's the point, really.
Yeah,
Make a will.
But it's will. Will is very important.
It really is.
Wow, Batswana ba utlwa gore will e botlhokwa tota. Bana se e gaisa lonyalo e gaisa dilo tse tsotlhe. I think it's life. Life is a will.
Literally, based on
Yeah.
experience, it causes one of the. It's such like there's so many disputes. Like, I've spent lots of time at the estate, and you can be there many times, and people will be in tears, and just it is really not a good position to put your family in. That's why I always say that if you have properties, just do a will. That's why you don't even need to tell them about it. Just do a will so that it avoids those issues.
Yeah.
And
And it's quite a very, I think the reason why sometimes even litigation in these type of matters is very long, because it's a very personal, it gets very personal and very emotional, that sometimes you'd find people arguing over the smallest things, like things that really they could sit down and just have a proper discussion on. I remember when I was still in UB, they came, a group of people, they were siblings, and they were having to litigate with their uncle, who wanted to take the borehole that they were left by their father. And the uncle was like, no, that is my brother's borehole. It belongs to me. It has been in the family for too long, and you are all women. You don't deserve this borehole. And it was just a very huge thing, and they were telling me that they had been having this issue since way before I even started university. And that's why I was like, wills are important for that reason, because had there been a will, they would have never had to go through that whole entire litigious process.
Another question to ask is, does the marital regime, in other words, whether you are married in community or out of community, decide in the end how your assets are going to be distributed, especially in a scenario where you died without a will, where you died intestate?
Yes, it does.
Explain.
Well, as already mentioned, if you are married in community of property, you're already entitled to 50% of that particular property, and then we have to consider whether there are children of the marriage, right? And then we have to the remaining 50% would have to be divided amongst the spouse and the children.
Yeah, the spouse gets a child's share.
Yes.
On top of their 50%.
Indeed.
Okay. Now, another scenario where now it's out of community. You're married out of community, but you died intestate without a will.
Do you wanna?
Yes, I'm married out of community property. Like, as earlier stated, okay, your spouse gets the same portion if you have children, equal portion as your children. So everyone gets, the children and the spouse get equal portions. And if there are no children, then as we stated, that then the parents and siblings will also all get equal portions.
In other words, is there an advantage to getting married out of community in terms of how your estate is divided if there's no will? Do you know what I'm saying?
If there's no will, there are certain advantages of being married out of community or property that I think we discussed in our earlier episodes. But when it comes to, as what I just stated right now was in an event when there is no will. So if you're okay, because some people obviously they'll be all right with that distribution. They don't mind the wife getting equal portions, the same as the children. And if you are fine with that, then that's what will happen. So it really just depends on the
so they participate only in the child share. Your surviving spouse who's married out of community still participates in the child's share?
No, if it's out of community or property, what happens is that they are entitled to what would be the same portion as the child's share. So in other words, it will just be equal portions.
If there's no will.
If there's no will.
So out of community doesn't it totally exclude the surviving spouse?
No, it doesn't. So if you don't want your spouse to inherit, then you must do a will.
You must do a will.
I think that's very important to
Yes.
clarify. A lot of people don't know that.
No, that's true. A lot of people think that out of community property, then definitely my spouse will not inherit. No, but they do have a portion to that.
Okay. Now let's talk about adopted children. Actually, the concept of legitimacy or illegitimacy, is this still a thing in our law, and how is the law view it in the law of inheritance and the law of succession?
As long as you're a biological child of the person who is deceased, then you have a right to inherit. And it depends on all these circumstances, whether they were married, will, etc. Yes.
So that is. Oh, I'm so sorry.
okay.
No, you go ahead.
That's very interesting, because I clearly need to keep myself updated in that particular law, because I thought that we were still following the whole, we have to sit down, consider whether the person was a tribesman, and then we have to consider whether that particular customary law that this person wanted to be guided by is to the effect that the child can inherit if they're an extramarital child.
You see, what you're saying, it depends. Yes, customary law it does matter when you're dealing with now interpretation of the other laws, such as the ones that we've been discussing through this conversation. So if it's true, because that's not my area in the sense of customary law, but I do know that when it comes to customary law, then certain acts do not apply to people who are tribesmen, for instance. So if the person was a tribesman, then it would be in terms of
that particular.
Customary law, what it says about that.
But the common law is to the effect that the biological child is to inherit.
Yes.
All right.
Yes.
When I was studying the law of persons, the impression we're given is that the reason why there's legitimate children and illegitimate children is to protect the institution of marriage, so that children who are born within that sacred institution are given certain benefits and rights and priorities. Now, from this discussion, I get the impression that is no longer the case.
It's no longer the case because, you see, that's why there's such laws like the marital power. For instance, that act was abolished a long time ago, which had to do with the man having power in the marriage and certain rights over the wife. So when it comes to this issue of inheritance, the law does recognize and acknowledge that you have a right as a biological child to inherit, unless there are wills, for example.
Ke botsa gore anong ha ile gore lo bana mo lapeng lo batlhano irile lo at primary school level ya lo kana yana Botswana bana la go ira jalo e be gore wa tsewa botla go golela mo family e nyenyane yone o se ngwana go wa adoptilwe mme not legally bo gola ya la ka Setswana bo gola ya la wa gonna motona
ya ke re ke mo go teng o tsaletse semama
bo a gonna ko gore ha o kgaogangwa dithoto a gona sheka gore wa bo berekile ko ne go irwa ya lo bereka ka bana bang ba dira gore is it mola wa reng ha o kgaogangwa dithoto a o ne yalwa sengwe kana o kubiwa ya la go te nya re batla bloodline ya la re batle ba adoptilwe.
You're not considered in terms of when you're dealing with estate issues, because as I said, you have to be either biological or legally adopted. If not, then that's why we go back to what we've been discussing, do a will. So you include them in inheritance, because you see, that's why you have to do things in the legally appropriate manner. Unfortunately, and that's the purpose of why we're having these discussions and educating the public about such things. Because, you know, in that type of situation, it could be a painful situation. And the person who raised that child obviously must intended them to benefit. But unless you are educated about these things and you know, then you at least know what are the options legally.
Okay, what about an adopted child? Are they treated at par 100% with a biological child once adoption takes place?
Yes, once they're legally adopted, the same status as a biological child.
Okay, and can the adoption be challenged by an aggrieved party, just like everything else?
You know what, now okay, what can happen is that a child can be adopted, and then later on, and you know, you can adopt a child even if they have maybe one parent who's alive, for example, but you are just adopting the child for whatever reasons. Maybe you've raised them, and you know, and it's a whole court application. Yes. So what can happen is, in terms of the Adoption Act of Botswana, you can come back later. You can either ask for a rescission of that adoption. And such instances where I've seen is that, for example, a father changed his mind, and currently he has a relationship with that child, and he was the biological father. So over the years, he's been having a relationship.
What kind of relationship?
No, like he's been father-child relationship.
Okay.
Yes, no, that's what I mean.
Yeah, you had to clarify that.
Yes. No, like a proper father-child relationship. And then, but the child was adopted by someone else. But over the years, this relationship, father-child relationship has been developing, and now he wants a rescission. or the adoption, because now
And
he
they
wants
could get
to
it.
assume. It's a reasonable argument, especially if the child agrees. And the parents who adopted the child, they can oppose it, or maybe they won't even oppose it because they'll be like,
So then that would determine the ability to inherit if that application succeeds. And
if it succeeds, now they're no longer an adopted child of that
Like
person.
what's our ano a le gore o tsere ngwana wa le monyenyane o na le ditshenyegelo tse o godisa ngwana wa batho rra go a iphitlhile la mo tlogetsa a sena sepelene o mo godisa ba nna motona kana ka rona ere ka from there santse a le bo the say before 18 a ke rra wa re wa lo cancel go mo wa motsa a so re o ka go khote gore ke batla ditshenyegelo tsa go godisa motho.
I'll just have, the court will make a decision.
Yeah.
No,
And
but
the
in
court
that
makes-
case, I don't think you have valid grounds from the example you gave. I
Because
think
you were not in the child's
Yeah.
life.
No, I'm saying when now mo godisitse Mr. Mo.
You claim
The
on
family
claim your
that-
losses.
When you don't claim your losses because it's a loss. You are raising this person what at our bologa. Next thing, he was alive and then there was nowhere to be found. Then
I think we shall have a separate discussion on adoptions
Yeah.
and the consequences there. It's got a whole can of worms there. We will come discuss.
Okay.
Are there limits to what can be inherited?
No.
Why do you say that?
When you say limits, maybe can you
Anything and
elaborate?
everything can be inherited.
That legal.
Okay, no, not
Legal.
yes.
Yeah.
For instance, someone is saying here in my notes, can a wife be inherited?
No, that's another.
No.
It has to be legal, lawful. It
Yeah.
has to be lawful.
Yeah. With the
So no, a wife can
Only under Botswana culture, right?
I've heard of
Yeah,
it.
that's not a culture that has malo ba gore seantlo se teng ya la you inherit.
So say what?
Seantlo.
Sian-
But is it inheriting the wife though? Shouldn't the wife consent to the
Marriage
marriage?
consent.
Hey.
It's always consensual.
Oh,
So
okay.
okay.
Yes. So yes, there are limits.
Can a loan be inherited?
No, a loan can't be inherited.
Unless it's a bond. You've been given a house
Yes.
and it's owing.
correct.
So there are exceptions to every
True.
rule.
True.
What happens if the deceased died without clearing his loan? I think we already touched on this.
Yeah.
Yeah.
we've
Okay, that
already-
deals with administration.
But I
of
wonder,
estates,
yes, because I wonder if it's a loan with machonisa or a non-secured loan. How is that to be treated?
Well, if it's a loan with a bank, as you said, that there's a process that is dealt with at the master's office, and basically what happens is that there will be creditors and debtors, as was stated earlier, and the banks will need to be paid. They will need to be paid, and we said that it's true there are preferential creditors, and the banks is one of them, and it will lead to property being liquidated in order to pay them, and whatever
Yeah.
that's left will be distributed.
Okay, as we conclude our conversation, one of the last questions I want to put to you is that the dreaded phone call comes. Person has passed on. What is the first steps? What are the first initial steps to take in terms of winding up that estate?
Okay, I should answer.
Yes.
All right. The first thing when you get a call about someone passing away, the first thing is to get the death certificate, and that is not instantly out. I think maybe it can take a couple of days. I'm not 100% sure how long it would take, but you need that first in order to do anything when it comes to a deceased estate. That's the starting point. And then depending whether the person died a tribesman under customary law, then you would have to go that route, the customary law route. But if a person was not a tribesman, then you would have to report the death to the master's office, and there's a whole process and specific step by step that a person would have to follow.
Including the filing of inventories, etc.
Yes, filing of inventories, and even that they'll need you to submit, as I said, the death note, the death certificate, the register, the estate, and then with that, there are certain public notices that will have to be done. The first step is the next of kin meeting, where an executor would have to be appointed. And then after that, then it will be the creditors and debtors meeting. Then there'll be dealing with the liquidation and distribution of the account, you have to also submit that, and then after that, the estate will be.
I think the rest, if the viewer wants to hear more, they must come to your office.
But yes, that is the general process. So the first thing is you need to have access to the death certificate, because even all these other places, even if it's not going to court, when you're dealing with a person who's passed away, the first thing you need to do is to prove that they have passed away. Yes.
No, so that makes perfect sense.
But I will say this: you can't go to the bank and be saying that, okay, they had a bank account, you want to access the funds, here's the death certificate. I do have to mention that to the viewers. It's not that simple.
Often I see people dashing to the headman or to the kotla, and getting some kind of permission to access accounts, especially for purpose of the burial.
It
seems the headman can do a lot of things.
They actually also can. Or the master's office.
We've come to the end of our conversation. It's been a very fruitful and very powerful and energizing one. As we conclude, I want you to share your final thoughts in terms of this entire law of succession, what your views are on the state of the law, what you think needs to be changed, any suggestions as we wrap up. I'll start with Mr. Mabote. Okay, no, let's start with the lawyers so you can learn from them.
I think that I'm very much content with the position of the law in terms of succession, quite particularly succession, because there's been so many strides in terms of making it to be quite fair. And I think that it's quite evident in how much it has transitioned over the years. I mean, there were instances where there were court cases on whether a girl child can inherit and all of those things. But I believe that our law has really come so far in terms of that area of the law, and it has reached a very satisfying point. I learned something new today that, as long as you're the biological child, you are entitled to inherit under common law. That's something that I wasn't aware had been sorted out. That was my only big issue with this particular law. But I think with that, I'm very much comfortable with where it is so far. What I do think needs to happen is more conversations like this to educate people more about the importance of a will. Because even though the law has come so far, it can only go to a certain extent. It can only go so far, It's also upon you as a Motswana to see that you secure everything, you leave behind peace. I know that usually when this topic of succession is discussed, it's referred to as ruling from the grave. So rule in peace, get a will, and get your affairs in order.
So it's a good idea to rule from the grave, but do so in peace.
Indeed.
It's a powerful message.
Gore tota ka gile ka tlhalosa le gore ha o sa batle gore o ne go te wa ikotlolla o tlhokagetse go nna sepoko ke gore ala o bone gore o ya go diagenteng wa go Lerumo mo go be legal practitioners kanto diagente dingwe tseo di itseng o ya go ira will ke yone se se tsontse re ke se bua gore ke le mogile gore ne ke ntse ke tsore will tenyana ne ke ntse ke akanyala mo sa face ka will
dipoko ke batho ba sa irang di will
ke batho ba ile gore ba gore ga tona se ka gore gona se mo se lebetse mo le hasi mme ga ntse itlala le assets kana go ntse ha ke gane lo ratolo tlo nne teng go teno I love someone but mo go botlhoka tla go teng motho kana go tse bana ba go ba tsetse dio tsotlhe go ke maloma bone kana ke tsore ga ntse go ate motho a teng wa batla poki mme ja no ke bua ke gona na sona gona le ntlhengwe ke batlang go gatela ke gore ha ke tlhaloganya kgotsa ke ra gore ke tsa gore ka ba ka ngwa ke a tribesman ya ka ntse le bua gore ke anya seng gore ke nkare selective ke ha ngwana o ne gore go disitswe mo Setswaneng a adoptilwe mo tsera le monyegoto ra go monela kana ha go tswale go la gore ngwana ke tsholela go senotse ngwana o a ba go nna ko lapeng a nna le nna boselo jwa go botlhe ke be ke tshola bana ba bangwe mme ngwana o go te ke motsholetswe ke mo godisela ka waka e re ano ke tlhokagala ngwana o ke motsholetswe ke mo sa iriswe one mola wa Setswana one ya no ke go tsamaya go tsa wa sekgwa a ba le kiwa sa neelwe sepe sontsore mola wela go re khokona gore ngwana adoption e ne gabedi go wa adopta ka Setswana o gona go adopta ka Sekgowa ka gore e le mogemela yotlhe ka bobedi nna ke yone view ya me gore a go ba ka ngo gore batho ba gore batho ba kubilwe mo lapeng ba le bantsi ba leng gore ba le go sola thata re bone ba gola le bona la bona.
Thank you, Mr. Mabote. Thank you for those wise words. Nyerenda, you have the last but one opportunity to wrap up.
Yes, I believe that this discussion has been very informative. The main thing is seeing that it really is the best decision to have a will, especially if you have assets that you want to protect and have them distributed in a way that you want them distributed. Because if you don't have a will, the only other way is what the law determines on how your property will be distributed. I think from a few examples that have been stated in this discussion, it can really end in tears for a family if you do not have a will, and those will not be your wishes, you leaving that property behind. So I would just want to emphasize and really appeal to everyone watching this program. If you have assets, property, do a will. And our law firm, we do wills at Lerumo Mogobe Legal Practitioners, and we encourage you to give us a call, and we will definitely assist with drafting wills. We have extensive research experience, in that area, and it's the best thing that you can do for your family. And also, as I stated, it'll be your wishes that you'll be putting in a will. Thank you.
Thank you very much. It remains for me to thank my able panelists, and also to point out that the reason we've committed ourselves to this legal series is to empower the public. It's part of our ethos: enthuse, energize, empower, and inspire. So we're trying to do this through life-changing information that is impactful. And I'm sure you'll agree with me that we've had a very, very powerful panel who have enlightened you. So let me just remind you to strike that subscribe button so that we make sure that we remain on air, we remain capable of providing this information. So I thank my fellow panelists, but before I go off air, the book is there, 360. It's available here. It's available at Exclusive Books. In addition, this program is powered by Lerumo Mogobe Legal Practitioners. Their number is 397-4002. So if you want to get hold of them, feel free. And the email, the partners at lerumomogobe.com. So it's available for you also via email. But let me just wrap up by getting each individual member here just to say where they can be reached very quickly, your contact details, and then we wrap up.
You can reach me on Instagram, or you can contact me on 7528-6203. Instagram, it's at Letshwenyo. I'm yet to create pages for my law firm. It's quite remotely new, but I believe that will be up and running on Facebook and all other social media platforms soon.
Congratulations, my law firm.
Thank you.
Motlana go ira law firm go ra ro botlhale. Ya no nyame na re bona ela mo go be plaza. Ha re ba tla re mo go be incorporated. Number ra rona ke quad 79904. Re bua yana ra subscribe to this program Mogobe Nuggets of Wisdom. Ke ta bua gabedi. Subscribe to Mogobe Nuggets of Wisdom.
Thank you.
Yes, you can find me at Lerumo Mogobe Legal Practitioners. We are at the Mogobe Plaza CBD, second floor. Our contact is 397-4002. And we do have an Instagram page as Lerumo Mogobe Legal Practitioners. We also have a Facebook page, as well as we're on LinkedIn. My personal pages are in my name, Thokozile Nyerenda. On Instagram, it's Thokozile. Thank you.
Thank you very much. You've been a very, very good audience. We appreciate your listenership. Thank you, my fellow panelists. Bye-bye.
Bye-bye.